When I first bought my cabin in the mountains, the last thing on my mind was a homeowners association. The nearest subdivision was 3 miles away, separated from my land by a county road, a creek, and a strip of forest I'd legally acquired years before. I'd chosen this property specifically because it was outside of any HOAS control, a place where I could build, maintain, and enjoy life without nosy board members peering over my shoulder or telling me what color my siding could be, but apparently, the board of the Maple Ridge HOA didn't see it that way, or maybe they did and just thought they could bully me into paying them anyway. It started with a letter in a plain white envelope, no return address, just my name and cabin address printed in a generic font, the kind you might expect from a utility bill or junk mail. Inside was a notice of violation and assessment, a fine, claiming that my cabin had been improved without prior HOA approval, and that I owed them $30,000 in fines, due within 30 days. I laughed at first, genuinely thinking it was some kind of scam from a fake HOA. After all, they listed violations like non-conforming roof color and unauthorized landscaping, which were absurd not only because my metal roof was a natural gray and my landscaping was just native pines and wild grass, but because I'd never once had any agreement, covenant, or membership in Maple Ridge's HOA. I tossed the letter aside, thinking that was the end of it, but 2 weeks later, a man in a golf cart, yes, a golf cart, all the way out here, pulled up my gravel drive wearing a Maple Ridge HOA polo shirt and carrying a clipboard introducing himself as HOA Compliance Officer Greg, which sounded like the punchline to a bad sitcom. Greg informed me in a clipped tone that I was now officially in violation and that failure to pay or remedy the infractions would result in legal escalation. I told him flatly that they had no jurisdiction over me, that my property wasn't in their subdivision, wasn't part of their plat map, and wasn't subject to their bylaws, but he just smirked and said, "We'll see about that," before turning his golf cart around and rolling slowly down my drive like he was making a point. The next week, I got another letter, this time via certified mail, repeating the fine amount and adding late fees. That's when I realized this wasn't just a stupid misunderstanding. It was an intentional move to pressure me, maybe, even to set up a lien, and I needed to shut it down hard. So I drove to the county records office with every scrap of documentation I had, my deed, my survey maps, the legal description of my parcel, and even the original subdivision map from when Maple Ridge was platted, and sure enough, my property was nowhere near their jurisdiction. I also learned something interesting. The HOS board president, a woman named Linda Marsh, had a history of trying to annex nearby land into the HOS control, usually by convincing or pressuring small property owners to sign membership agreements in exchange for access to amenities they never actually used. I had no doubt she thought she could steamroll me the same way. Armed with my proof, I sent them a certified letter of my own, citing county, plat maps, my property deed, and state statutes making it clear they had zero authority over my land. I also included a cease and desist order, warning that any further attempts to collect money from me would be treated as harassment and reported to law enforcement. I figured that would make them back off, but clearly I underestimated their arrogance, because just 3 days later I got a notice taped to my cabin door claiming that a lien had been filed against my property for the unpaid $30,000 fine. Now I was furious. A fake lien, especially one recorded publicly, could cloud my title and complicate any future sale or refinancing. And the fact that they thought they could get away with it told me they'd pulled this trick before on someone who didn't fight back. I called the county clerk immediately, and sure enough, there was no valid lien recorded. The HOA had just pretended to file one, posting a document on my door that looked official but wasn't in the county system. That crossed the line from annoyance into fraud, and I knew then that I was going to take this as far as it needed to go, not just to protect my own land, but to make sure Maple Ridge's board learned that messing with people outside their jurisdiction could land them in very real legal trouble. So I called an attorney I knew from a past business deal, a sharp, relentless guy named Thomas Reed, who specialized in property disputes and wasn't afraid of messy fights, and I laid out the entire situation. from the fake fines to the bogus lien notice. Thomas's eyes lit up when I mentioned the fraudulent lien, because in our state, filing or even simulating a lien without legal grounds wasn't just a civil issue, it was a criminal one. By the end of our meeting, we'd mapped out a plan. We'd file a civil suit for harassment, defamation of title, and attempted fraud, while simultaneously referring the matter to the district attorney for possible criminal charges against the individual board members who approved the action. Thomas also suggested we send a public records request to the HOA for all communications regarding my property, something they'd be legally required to produce, because if they'd conspired internally to target me, we'd have them dead to rights. I left his office feeling a mix of anger, adrenaline, and satisfaction, because this wasn't going to end with me just proving I was outside their jurisdiction. It was going to end with them explaining to a judge why they thought they could fine and threaten a man whose land they had no legal claim to, and I had every intention of making that explanation as humiliating and costly for them as possible. Thomas wasted no time. The very next morning, he sent Maple Ridge HOA a formal demand letter on his law firm's letterhead, the kind that makes anyone with half a brain think twice before ignoring it. The letter outlined in painstaking detail how my property was not and never had been part of their, included copies of my deed, plat maps, and a sworn affidavit from the county surveyor confirming the jurisdictional boundary, and warned them that continued attempts to fine, harass, or threaten me would result in civil and criminal proceedings. He gave them 10 days to respond, but honestly, neither of us expected them to back down, and sure enough, on day 4, Linda Marsh herself showed up on my property, driving a shiny black SUV that looked comically out of place on my gravel. Drive, stepping out in heels and a blazer like she was about to give a TED Talk on how to ruin someone's week? She didn't bother with pleasantries, just launched into a speech about protecting the character of the community and maintaining standards, and how my cabin set a bad precedent if left unchecked. I let her talk, partly because I wanted her to dig herself deeper, and partly because Thomas had suggested I record any interactions for evidence, so my phone was sitting on the porch rail, quietly capturing every arrogant word. When she finally got to her point, that if I just paid the fine and joined the HO, all this unpleasantness could go away, I asked her point blank, "Are you aware my property isn't in Maple Ridge?" And she actually smirked before saying, "Boundaries are negotiable when the good of the community is at stake." That line right there was gold, not just for my case, but for showing intent, because she'd essentially admitted they knew I wasn't under their control but wanted to rope me in anyway. After she left, Thomas and I filed the lawsuit, counts of harassment, slander of title, attempted fraud, and civil conspiracy, and at the same time, we sent the entire file to the county district attorney, attaching Linda's recorded statements. It didn't take long for things to get interesting. Within a week, Maple Ridge's attorney, a stiff, gray-haired man named Jeff Walters, called Thomas demanding that we resolve this quietly to avoid negative press, which told me they were already feeling the heat. Thomas told him flatly that the only resolution was a public apology, withdrawal of all claims, and compensation for damages, which included my legal fees and a hefty sum for the attempted lien. Walters scoffed and said we were overreaching, so Thomas simply replied, "See you in court," and hung up. Meanwhile, the district attorney's office sent investigators to interview me, collect the bogus lien notice, and review my recordings. The lead investigator, a no-nonsense woman named Carla, told me off the record that this wasn't the first complaint about Maple Ridge's board trying to push beyond their boundaries, but it was the first with such clear documented proof. A month later, the court date was set, and the day filed misdemeanor charges against Linda and 2 other board members for filing a fraudulent lien and attempted extortion, which sent shockwaves through their little gated community. I heard from a friend who lived near Maple Ridge that their board meetings had turned into shouting matches, with some members demanding Linda step down before she dragged them all into bankruptcy, and others insisting they had to fight this to protect the HOA's authority. In the lead-up to the trial, Thomas subpoenaed all HOA communications related to me, and when their attorney tried to stonewall, the judge ordered them to comply. What we got back was even better than we'd hoped. Emails between Linda and the board openly discussing how my land wasn't in their jurisdiction, but deciding to test the waters by fining me anyway to see if I'd pay, plus one email where Linda bragged that if they could get me under HOA control, they could use as creek access to boost property values for homes in their subdivision. That one sentence blew the whole thing wide open, because now it wasn't just about money, it was about them trying to seize a resource that didn't belong to them. The first pretrial hearing was almost comical. Linda strutted in wearing a bright red suit, glaring at me like I'd personally declared war on her, while Jeff Walters shuffled papers and tried to act unfazed. Thomas laid out our case in calm, brutal detail, dropping the recorded quotes and email excerpts like grenades, and you could see the color drain from Walters' face. The judge, a stern man named Judge Ortega, seemed unimpressed with the HOA argument that they were acting in good faith to preserve community standards, especially when Thomas pointed out that their community didn't legally include my property. Ortega ordered the criminal case to proceed separately from the civil suit, which meant Linda and her fellow board members were now fighting on two fronts and losing ground fast. In the meantime, Thomas advised me to keep documenting everything, because if the HOA tried anything else, even a nasty letter, it could be added to our harassment claims. Sure enough, 2 weeks later, I got a flyer in my mailbox from Maple Ridge claiming that certain properties near the subdivision were under review for mandatory inclusion and warning owners to comply now to avoid penalties. Thomas practically rubbed his hands together when he saw it because it showed a pattern of intimidation beyond just me. By the time our civil trial date rolled around, the local paper had picked up the story, running a headline that read, faces lawsuit, criminal charges over out-of-bounds fines, and from that point on the public pressure was just as damaging to them as the legal battle. I knew then that no matter how this ended, Maple Ridge's days of bullying people outside their gates were numbered, and I was more determined than ever to make sure their board didn't just lose in court, but learned the hard way that their authority ended where my property line began. The morning of the trial felt like walking into the lion's den, except the lions were wearing tailored suits and trying desperately to hide the scent of fear. I arrived at the courthouse early, Thomas at my side, and we both noticed the small knot of reporters gathered near the steps. Clearly word had spread beyond our sleepy county, and now local TV crews were looking to catch the drama firsthand. Inside, the courtroom was already buzzing, with Maple Ridge board members clustered on one side whispering urgently, while Linda Marsh sat at the center like a general rallying her troops, wearing another power suit that probably cost more than my truck. When Judge Ortega entered, the room went silent, and from the moment he looked over the docket, I could tell he wasn't in the mood for theatrics. Thomas opened our case with surgical precision, laying out the timeline of harassment, the fraudulent lien, and the clear evidence that the HOA had known from day one that my property was outside their jurisdiction. He played the recording of Linda saying boundaries are negotiable for the good of the community, and the sound of her own voice echoing through the courtroom was almost comical, especially when a few people in the gallery audibly chuckled. Walters tried to counter by claiming Linda's words were taken out of context, and that the HOA had a reasonable belief they had authority. But when Thomas pulled up the internal emails where they explicitly acknowledged I was outside their boundaries, that argument died on the spot. Next came the part that really turned the tide, the subpoenaed financial records showing that Maple Ridge's board had allocated $15,000 from HOA dues specifically for acquisition of creek rights and had listed my property's parcel number in the notes. When Thomas asked Linda on cross-examination if that meant they planned to take my creek access, she tried to dance around the question. But Judge Ortega wasn't having it. He ordered her to answer yes or no, and when she reluctantly admitted it was true, you could feel the oxygen leave their side of the room. Walter's strategy quickly shifted from denial to damage control, suggesting that negotiating for resource access was a standard community practice. But Thomas pounced, pointing out that negotiating didn't involve filing fraudulent liens or issuing illegal fines. During the recess, I overheard two board members, a tall man in a navy blazer and a shorter woman with a clipboard, arguing in the hallway, the man hissing that this is all Linda's fault and that they should have dropped it months ago. By the time we resumed, the cracks in their united front were showing. One board member outright contradicted Linda's testimony about whether they'd voted to target my property, and another admitted under oath that they'd relied on Linda's assurances about jurisdiction without checking the actual maps. This gave Thomas the perfect opening to suggest that the board had been misled by its own president, effectively planting the seed for them to turn on her to save themselves. The criminal case loomed heavily in the background. Carla, the investigator, was sitting in the back row taking notes, and I could tell from her expression that she was already cataloging the perjury and obstruction angles. Things got even more chaotic when Thomas introduced the flyer Maple Ridge had sent to certain properties warning about mandatory inclusion. The judge raised an eyebrow and asked Walters how that didn't constitute intimidation, to which Walters stumbled through a weak explanation about informational outreach. Ortega simply said, "We'll let the jury decide," which made Walters' shoulders slump. On the second day of the trial, we called the county surveyor to the stand, and he brought large, laminated maps showing the official boundaries. When he pointed directly to the line and confirmed my property was outside Maple Ridge by nearly a quarter mile, you could see several jurors exchange glances. Linda tried one last Hail Mary on the third day, testifying that I'd been uncooperative and hostile from the start, but Thomas calmly asked, "Would you describe recording a trespasser on your property as hostile?" Which got a small laugh from the jury. In closing arguments, Thomas painted a clear picture. This wasn't a misunderstanding. It was a calculated attempt to expand the HOA's reach, secure valuable creek access, and squeeze money out of someone they knew they had no authority over. Walter's closing, by contrast, felt scattered and desperate, hinging on the idea that the jury shouldn't punish the whole community for the mistakes of a few individuals, which was ironic given that Linda was still sitting in the middle of her board like a queen on a sinking throne. When the jury came back, it wasn't even close. They found in my favor on every count, awarding me damages that covered all legal fees plus a sizable sum for harassment and emotional distress. The best part, though, was the judge's order, requiring Maple Ridge to formally retract their lien, issue a public apology, and record an affidavit with the county confirming they had no jurisdiction over my property or any rights to my creek. As soon as court adjourned, the reporters swarmed, but I kept my comments short. Property rights matter. Lines exist for a reason, and let Thomas handle the rest. Outside, I saw the board members scatter like pigeons, some clearly furious with Linda, others just looking shell-shocked. Later that week, I learned from my friend in Maple Ridge that 3 board members had resigned, and at the next meeting, residents were openly calling for Linda's removal. But the real cherry on top was hearing from Carla that the DA was moving forward with the criminal charges, and that in light of the trial testimony, they were considering adding conspiracy and attempted grand theft to the list. It was clear that while my civil case was over, Linda's nightmare was only beginning, and I intended to watch every minute of it unfold. By the time Linda's criminal trial began, the public's patience for HOA power games had worn thinner than cheap paint in a rainstorm, and the courthouse steps were practically a circus, reporters with tripods, homeowners holding signs, reading HOA equals Hands Off America, and even a guy selling t-shirts with Linda's face over the words, "Jurisdiction Junkie." I arrived early again, not because I had to testify yet, but because Carla had asked me to be there to show a united front as one of the key victims. The DA's office had built their case like a fortress, wire-framed with paper trails, fortified by witness testimony, and capped off with recordings so damning they made even the most diehard supporters wince. The prosecution started strong, calling a former Maple Ridge treasurer who, after being granted immunity, laid out exactly how Linda had orchestrated the campaign against my property, including instructing the board to push the lien through fast, so I'd be forced to negotiate, a word she clearly loved, but which, in this context, sounded an awful lot like extortion. Next came the county records clerk, who testified that Linda had personally submitted the fraudulent lien paperwork, signing as authorized agent for a jurisdiction she knew didn't exist. The defense tried to argue that Linda had been acting in the best interest of the community and had misunderstood the property lines, but that fell apart the moment the surveyor took the stand again, holding the same laminated maps from my trial and pointing to the big, undeniable gap between my land and Maple Ridge's boundary. The DA then played a series of internal meeting recordings, one of which featured Linda joking about how easy it is to scare people with legal language. That one landed like a brick in a glass house. Walters, still clinging to the impossible, tried to get those recordings thrown out on the grounds of irrelevance, but the judge, a no-nonsense woman named Judge Nguyen, shut him down with a curt, "They go directly to intent. Counsel, sit down." When it was my turn to testify, I kept it calm and factual. I described the visits from HOA board members, the bogus fines, the threatening letters, and how it all culminated in that lien showing up like a bomb in my mailbox. Walters tried to trip me up, asking if I'd ever considered working with the HOA voluntarily, to which I replied, "Work with them to take what doesn't belong to them." "No, sir," and the jury chuckled, which clearly irritated him. But the moment that really broke Linda's composure came from someone she probably never expected, her own vice president, Robert Sloan, who testified that he had warned her multiple times they had no legal standing over my cabin and that pushing forward would get us all in trouble. When asked why he didn't go public sooner, he looked right at her and said, "Because I thought she'd stop before it came to this." And the room went so still you could hear the bailiff shift in his seat. Over the next few days, the prosecution piled on bank records showing HOA funds diverted to pay Walters for the lien filing, emails where Linda told members to keep this off the official minutes, and a particularly damning message in which she referred to me as an easy target because I was out here alone. Walters tried one last desperate angle, painting her as a passionate leader who simply lost her way, but by then the jury had seen too much. When closing arguments came, the day leaned heavily on the theme of abuse of power, reminding the jury that HOAs operate under the trust of their members, and when that trust is weaponized against outsiders, it becomes criminal. Walters tried to downplay the intent, claiming Linda's heart was in the right place, but it was hard to reconcile that with the evidence of her laughing about scaring people. The jury deliberated for less than 4 hours before returning a verdict: guilty on fraud, guilty on filing false documents, guilty on attempted grand theft, and guilty on conspiracy. Linda's face didn't change much as the foreperson read the verdicts, but her hands tightened into fists on the defense. Table, knuckles white. Sentencing was scheduled for a month later, but Judge Nguyen didn't let her walk free in the meantime. She was remanded into custody immediately, and the sight of her being led away in handcuffs while cameras flashed was something I won't forget anytime soon. Outside, Carla told me this was one of the cleanest HOA takedowns she'd ever seen, and she fully expected it to set a precedent for similar cases across the state. In the weeks that followed, Maple Ridge was a ghost of its former self, with Linda gone and several other board members under investigation. Residents began pushing to dissolve the HOA entirely, citing the damage to their reputation and finances. I heard from my buddy in the neighborhood that attendance at meetings had dropped to single digits and that half the community wanted nothing to do with enforcement anymore. Meanwhile, I went back to my cabin, repaired the last bits of damage from the months of harassment, and sat by my creek one evening watching the water flow, realizing just how close I'd come to losing my peace to someone else's greed. But Linda's story wasn't over yet. Word came down from Carla that at sentencing, the DA was going to push for restitution not just to me, but to every homeowner in Maple Ridge whose dues had been misused, which meant the fallout would ripple even further. As the date drew near, it was clear that whatever happened next would not only end Linda's reign for good, but also leave a permanent mark on how far an HOA could go before the law finally slammed the door in their face. Sentencing day arrived under a gray sky that seemed fitting for the final chapter of Linda's downfall. And the courthouse was packed to capacity, not just with media and Maple Ridge residents, but with a surprising number of people from outside the county who had followed the case online and now wanted to see the woman who had become a national example of HOA overreach brought to justice. The public gallery was so full that deputies had to start turning people away at the door. And still, the crowd outside swelled, chanting HOA reform now and waving homemade signs. Inside, Judge Nguyen presided with the same cool authority she'd maintained throughout the trial, and you could tell by the set of her jaw that this was not going to be a slap-on-the-wrist kind of day. Linda was brought in wearing an orange jumpsuit instead of her usual tailored blazer, her hair less perfectly styled, though she still tried to keep her chin high as if this were just another HOA meeting she could control. Before the sentencing, the court allowed victim impact statements. And the first to speak was me. I stood at the podium, took a breath, and told the court exactly how Linda's actions had disrupted my life. The endless letters, the false fines, the threat of losing my cabin to a lien that should never have existed, and the months of stress that came with fighting a battle I never asked for. I made it clear that this wasn't just about me, it was about anyone who'd ever been bullied by an HOA that thought it could invent authority where none existed. Next came several Maple Ridge homeowners, some of whom admitted they had supported Linda at first, until they realized she was siphoning their dues to pay for her legal crusade against me and other outsiders. One elderly resident, Mrs. Holloway, shook as she spoke about how she had skipped buying medicine one month because Linda told her they needed the funds urgently for community protection, only to later find out it had gone to Walters' law firm to file bogus claims. By the time the last statement was read, even a few of Linda's former allies in the audience looked sick to their stomachs. The DR recommended the maximum sentence allowed, 5 years for the fraud and false filing charges, plus restitution, to all victims with a pointed reminder that leadership is no excuse for lawlessness. Walters, clearly worn down from the loss, asked for leniency, arguing that Linda had already suffered enough from public humiliation, but Judge Nguyen was unmoved. When it came time for Linda to speak, she finally dropped the haughty tone and tried for contrition, claiming she had only ever acted out of a desire to protect Maple Ridge's values, but the apology rang hollow, especially when she still tried to imply that I had been uncooperative and provocative by refusing to acknowledge their community guidelines. Judge Nguyen cut through it, telling her bluntly, "You abused a position of trust, you falsified documents. You attempted to steal property that wasn't yours and you did it knowingly. The court is here to protect the public from exactly this kind of behavior." Then, with the room holding its breath, she handed down the sentence, 4 years in state prison, full restitution of the $30,000 fine they had tried to impose on me plus legal fees, and an order to repay nearly $120,000 to Maple Ridge residents whose dues had been misused. Linda blinked hard but didn't cry, though her jaw tightened so much I thought she might crack a tooth. As deputies led her away, the crowd outside erupted into cheers that carried even into the courtroom. In the weeks that followed, Maple Ridge HOA effectively dissolved. After the state audit revealed just how deeply Linda's mismanagement had gone, residents voted by an overwhelming majority to terminate the association and transfer common area maintenance to a private contractor, freeing themselves from any future board power plays. The story hit national news cycles, sparking debates on HOA reform laws, and I was even contacted by a state senator's office for input on proposed legislation that would limit HOA jurisdiction strictly to recorded boundaries, with criminal penalties for enforcement beyond them. As for me, I returned to my cabin and reclaimed the peace I'd fought so hard to keep. The creek still running clear, the trees still swaying in the wind, but now with the knowledge that my battle had helped draw a line in the sand for countless others. Every so often I'd get an email from a stranger saying they'd read about my case and used it to push back against their own overreaching HOA. And I'd think about how one bogus fine had snowballed into a movement neither Linda, like her, could stop. Linda will serve her time, Maple Ridge will rebuild without a boardroom dictatorship, and my land remains mine, untouched, unclaimed, and beyond the reach of anyone who thinks jurisdiction is just a word they can twist to suit their greed.